Okay, I see folks are still joining, but we're going to go ahead and get started in the interest of time. Thank you all so much for joining us today for today's discussion on protecting local democracy, defending attacks on prosecutors. My name is Rachel Marshall. I am the Executive Director of the Institute for Innovation and Prosecution at John Jay College. The IIP provides a national platform to bring together prosecutors, policy experts, and the communities they serve to promote data-driven strategies, cutting-edge scholarship, and innovative thinking. The IIP champions criminal justice reform policies that advance community-centered standards of safety, fairness, and dignity. We are delighted to be hosting today's event with our esteemed guest. The IIP has been especially invested in today's topic, protecting local democracy and defending prosecutors from attack. Over recent years, and especially we've seen in 2023, there have been coordinated efforts across the nation to undermine the role of prosecutors and disempower the local communities that elected them. These attacks have come in the form of legislation, recalls, impeachment efforts, and as one of our groups today personally experienced, one of our guests today, personally experienced even unilateral removal by governors. In Georgia, we've seen, and we'll talk about momentarily, a new law, SB 92, that established a commission with the power to remove locally elected prosecutors based on their use of discretion, and there's some big developments on that we'll be talking about today. In Florida, Governor Ron DeSantis suspended 2 local prosecutors, including our guest Monique Worell, despite them having been elected by their communities. And in many other states, there have been similar efforts to preempt the role of local prosecutors and undermine democracy. We know that these attacks have been targeting prosecutors who are responding to calls from their communities to implement reforms, to correct racial disparities in the legal system, to stop the criminalization of poverty, to reduce incarceration, and address the root causes of crime, just to name a few. Today, we're going to be talking about some of these attacks, and our guests have been on the front line of them. We'll also step back and discuss the implications of these attacks and how they can be responded to so that all communities have a voice in how their local elected officials address their needs. We have very esteemed panelists with us today, and in the interest of time, I'm going to introduce them very briefly, but we do have full bios available. We'll be placing a link to the full bios in the chat, and we encourage you to read more about each of our guests. I'm going to start with Sherry Boston, who stands among the elite in the world of prosecution as one of the rare 1% of African-American females currently serving as district attorney nationwide. DA Boston was first elected as district attorney for the Stone Mountain Judicial Circuit in 2016. In her capacity, DA Boston oversees the prosecution of felony offenses filed in the Superior Court of Dekalb County. DA Boston served as the lead plaintiff in a lawsuit filed in Fulton County Superior Court, challenging the constitutionality of Senate Bill 92, or SB 92, a law enacted by Governor Brian Kemp during the 2023 legislative session aimed at curtailing the power of locally elected officials and usurping the will of voters. Monique Worell is the duly elected state attorney for the 9th Judicial Circuit Court of Florida. She was elected in November of 2020 to bring reform to a criminal legal system that is fundamentally flawed in order to achieve equity and to move our system towards justice. She served as the chief prosecutor until August 2023, when Florida Governor Ron DeSantis suspended her. Carissa Byrne Hessick is the Ann C. and Garland Buck Ransdell Distinguished Professor of Law at the University of North Carolina School of Law, where she also directs the Prosecutors and Politics Project. Her teaching and research interests include criminal law, the structure of the criminal justice system, criminal sentencing, and child pornography crimes. She's the author of multiple law review articles, essays, and op-eds on plea bargaining, the powers and selection of prosecutors, Sixth Amendment sentencing rights, and criminal statutes. Welcome so much to our panelists. We're really excited to have you here for this really critical conversation. I do want to let our audience know before we start the conversation that we will reserve time at the end for Q&A. You can feel free to put them in the chat throughout our conversation, and we'll make sure to get to them at the end of today's program. So I want to start this conversation off with you, Professor. We're here in the context of a backlash against the same prosecutorial functions that have been in place from the very beginning of our legal system. And there was a time, it seems, when prosecutorial discretion and the amount of independence that we afford prosecutors was largely unchecked. There were no challenges to that idea. So I'm hoping you can start us off and ground our conversation by describing, first of all, what is prosecutorial discretion? And when did the backlash we are seeing against that discretion start to emerge, and why? Why do you think it started to emerge when it did?
Thanks, Rachel. I'm excited to be here and talk about this very important topic. And to understand the idea of prosecutorial discretion and what it means, I think we first need to acknowledge that we don't, and probably couldn't even if we wanted to, fully enforce the criminal laws in this country. Um, because we can't and don't fully enforce the laws, someone has to decide when the laws will be enforced and under what circumstances. And that job is given to prosecutors. They exercise their discretion, their decision-making authority to sort out those cases that they will pursue and those that they won't. Now, sometimes this decision is based on evidentiary concerns. Maybe there's enough evidence for probable cause, which is the threshold to bring charges, but they don't think there would be enough evidence to get a conviction. So they use their discretion not to pursue the case. Sometimes it's a resource question. The office can't possibly pursue every single case that they could secure a conviction with. And so decisions have to be made about which cases to prioritize and which not to pursue. But there are also sometimes policy considerations, either because statutes are written very broadly, and the prosecutors need to decide how to interpret them, or even just when something falls within the clear text of the statute, when they're not going to pursue it. I know sometimes people get really surprised to find out that prosecutors have this sort of authority. I think back to when Jim Comey got pulled in front of Congress because he wasn't fully enforcing all the time certain laws about classified communications. And he explained that the Department of Justice had enforcement criteria that it used, and everyone seemed outraged. But sometimes we actually see the opposite. We see prosecutors fully enforcing the law, and we see outrage there. One case that I really love comes out of Florida. It's from several decades ago. Florida had a law against gambling, and it had no exceptions. And a local prosecutor brought charges against some folks, some elderly people who were running a nickel and dime poker game, brought charges. There was an outcry. Some enterprising young journalist went to the newspaper and asked if they were going to change the law to exempt these sorts of nickel and dime poker games. And a member of the Florida legislature said, no, of course not. We're just going to hope that prosecutors in the future exercise better judgment. So legislators themselves know that prosecutors will and do exercise judgment. So why the backlash? I think the backlash is this discretion has largely gone unnoticed or untalked about. It's not the sort of thing that lawmakers usually say, we're going to enact this law, but we don't expect it to be enforced as written. It's sort of a strange thing for them to say. And even prosecutors often don't talk about when they won't prosecute cases. And so I think the backlash that we've seen here is prompted by the fact that within the past decade, we've seen really a new breed of prosecutors. Folks who've run on different types of platforms about reform. They're sometimes called progressive prosecutors. I know that can be a controversial term, but I think it's the term that resonates the most with the public. So these progressive prosecutors have been explicit about their discretion. They've run on platforms making clear what they would prioritize, what they wouldn't pursue. And frankly, they've been enormously successful. Our research at the Prosecutors in Politics Project shows that candidates who ran on progressive platforms had a much higher success rates than those who ran on traditional platforms. So maybe it was unsurprising that that level of success drew the attention of people who are not progressives, people whose politics are really at odds with the progressive movement. And because crime can be such an attractive political issue, a number of more conservative lawmakers, conservative officials have really lashed out against this movement, lashed out against these particular prosecutors who, and the policies that they've used when exercising their discretion.
I just want to ask a quick follow-up about that, because I know that there's trade-offs to both limiting discretion or not limiting. Can you talk a little bit about how you approach that balance and what you see as trade-offs of limiting discretion?
Sure. So as I said, we're never going to have full enforcement. It's just not, it's not sort of logistically possible to have full enforcement, at least not as our laws are written now. But any limits, and this isn't just true in the criminal justice system, but it's true more generally, that any efforts to limit people's discretion are often going to have unintended consequences, or maybe even just sort of strange consequences because how it will work. What you will probably have as efforts to limit transparency efforts to limit discretion gain traction and become successful is you'll see less transparency. You'll see people talking less, prosecutors talking less about how they use their discretion in order to not bump up against those limits. But you might also see some pretty perverse effects. So, for example, to the extent that legislatures mandate enforcement of certain low-level crimes that they think need to be enforced, you may see offices have to devote so many more resources to those crimes that they have to give out, that they can't put the resources into more serious crimes that are going on. So efforts to limit discretion are going to happen, and the effects just might not be what those people who are trying to limit discretion actually want to see occur.
I want to develop that last point you just made and turn to you, DA Boston, to bring you in, because to talk about sort of the practical effect. We just talked about how prosecutors, when they're told they have to prosecute every kind of offense, they're going to have to devote resources. How does that impact prosecutors on the ground? And how do these impacts or attacks on discretion impact the ability of a prosecutor's office to function?
Well, Carissa is absolutely right. And thank you once again for having me to be a part of this conversation. As district attorneys or any elected prosecutor, whether you are at the county level or the local city level, there is absolutely zero way to prosecute every offense that comes through your doors. And as someone that has been an elected prosecutor since 2011, I previously served as the misdemeanor prosecutor in my jurisdiction. And as misdemeanor prosecutor, we were in charge of prosecuting in traffic court, right? And that's the prime example. Like when we talk about people feeling like all of a sudden that prosecutors are going rogue and not prosecuting certain offenses, we have been making these decisions since the dawn of time. And I think traffic is the best place to put it. How many city court prosecutors that have a large traffic docket have to say, if you are speeding and it's less than 14 miles an hour, right? We are going to do this with your case. Perhaps it's dismiss it, reduce it to a warning, because we're going to focus on people that are going 30 miles over the speed limit, right? Which can be very dangerous, or habitual violators, or driving under the influence of drugs or alcohol, right? Those are the decisions that prosecutors make every day, because we know that the system would collapse if we had to prosecute every case that comes into our office. In the same way, there's a reason that only about 10% of criminal cases even go to trial every year for that same reason. The system would collapse. So having an elected prosecutor by their community make decisions about the prioritization of those limited resources, whether it's in the misdemeanor arena or the felony arena, or if it's an office that handles both types of cases. They have to be able to make these critical decisions about where to allocate their resources. And in my community, and the community that I serve, we want to put our focus on violent offenses, largely victim-based crimes, which means that we have to look at some of our laws and say, is there a better way to handle these cases, whether it's through diversion or a declination to charge, because the resources are not worth devoting to offenses that are not affecting our community in the same way that public safety is affected when we're talking about murder, rape, and armed robbery.
Thank you so much. I want to turn to State Attorney Worrell and start to turn to some of the specific examples that we've seen of these attacks on prosecutors. And we know, State Attorney Worrell, as I mentioned in my introduction, that Governor DeSantis suspended you earlier this year. And usurping power from state attorneys is not new in Florida. In 2019, then Governor Rick Scott took cases away from your predecessor. I want to turn to how you view your suspension in light of other suspensions on Florida state attorney, and if you see it as different or not. And also ask about how does your suspension fit in more broadly as part of this larger effort we're talking about to undermine prosecutorial discretion more broadly?
Well, thank you so much for having me. It's really great to be a part of this panel. I want to start by talking about how my suspension fits in more broadly with this usurping of power. For decades, in fact, if not centuries, what we've seen is discretion being used to treat people in the system more harshly as they see fit. And that discretion has led to mass incarceration in this country. We, as America, incarcerate more people than anywhere in the world. And here in the state of Florida, we do it at a rate higher than even the national average. And when people were using their discretion for the purpose of mass incarceration, for the purpose of the war on drugs, lumping more offenses together so that they could get lengthier prison sentences, that was okay. And as Carissa said, it was okay because crime in punishment is a sexy political token that people can use to get elected. And we see that now with the Florida governor in his race for president, continuously getting on debate stages, touting the fact that he's law and order and that he's removed 2 elected state attorneys here in the state of Florida as a show of his strength and power towards law and order. But the reality is, having spent 17 years as a law professor myself, we know that the research shows that incarceration doesn't stop crime. And even though we have very large incarceration rates, we still have crime in our communities in every state in this country. So it's really, as Carissa said, a point that's used for political gain. And there's really no substance behind what's being done with trying to usurp power. And it also does not help that the people that they're coming after, for the most part, are Black and women, right? Because those of us who have been most recently saying, we're going to do criminal justice differently, that's who we are. So yes, I was the second elected state attorney. In fact, this governor has suspended more elected officials than any previous governor in the state of Florida, and it's all been political differences. So the people who have been suspended for the most part have been Democrats, and he is a Republican governor. So the way that this governor has chosen to deal with political differences is by removing them, but the Florida Constitution doesn't allow for that, right? The Florida Constitution says that you can remove people who neglect their duty, who are negligent or involved in some sort of misconduct, if they've been arrested, if they are, addicted in some way, but not because it's political expediency. So what we see is the escalation of individuals usurping the power of prosecutors, and it has escalated to a fact where this governor has said, well, I'm just going to remove you. I don't like what you're doing, so I'm just going to remove you. And this is what we're seeing. So in August, almost a year to the date prior to my suspension, my colleague Andrew Warren from Tampa was suspended. Now, you asked how our cases were different. Our cases were different in that in Andrew Warren's case, the governor cited Andrew signing on to a brief that said, we disagree with prosecuting people for having abortions. We disagree with prosecuting doctors for performing abortions, and I'm not going to use my discretion in that way. And as we've discussed, there are different ways that people can use their discretion. And he said, I'm not going to use my discretion in that way. So the governor pointed to that as a blanket policy. as the Supreme Court in the case against Aramis Ayala said, you may not, as a prosecutor, have blanket policies, and that is considered to be an abuse on discretion. And the governor cited to that and said, this is a blanket policy. Well, let me be very clear. That suspension was wrong. But what the governor being able to get away with that suspension led to was my suspension, right? It's really, if you look at the analogy of the frog, you throw the frog in boiling water, he's going to jump out. But if you throw him in cold water and gradually increase the temperature, then he doesn't realize that he's boiling. Well, that's what's happening to the democracy here in the state of Florida. It's being done slowly, and it's being ratcheted up very slowly. So we're losing our democracy, but people don't realize what's happening, and what's wrong begins to seem right. So because he got away with suspending Andrew Warren for using his discretion to say that he would not prosecute abortion, he was able to suspend me with no basis at all whatsoever. The basis that he gave was neglect of duty, but he wasn't able to point to any specific acts of neglect of duty because there weren't any. So the way that our suspensions were different is that there was a specific act that the governor was able to point to in Andrew Warren's case, whereas in my case, there wasn't one. But fully escalating from his case, because he got away with it, he was able to go ahead and suspend me. And if he gets away with this, there'll be no limit to what he can do here.
Thank you for sharing that. And I think that analogy of the frog is true nationally as well, in terms of the multitude of attacks that we're seeing on discretion nationwide. And I want to turn a little bit to some of those legislative efforts that we've seen. Carissa, I'm going to turn to you first, because part of the strategy that we've seen has been legislation that allows for, as we're going to talk about in a moment, the removal of prosecutors, as in Georgia. But there's also similar bills that have passed in Tennessee, Texas, Iowa. I'm wondering if you can give us a little bit of a summary of some of the state laws that we've seen either passed or proposed to undermine discretion, and pull out what are some common themes that we're seeing in these legislative efforts.
Definitely. So it became clear that a lot of states were at least introducing legislation aimed at pushing back against prosecutors over the past few years. And so a colleague of mine, Rick Sue, who's an expert in state and local government law, he and I got together and we wrote a paper. I'm not sure that it's out yet. It's forthcoming in the Wisconsin Law Review. And that paper went through a lot of these pieces of legislation and divided them into essentially three categories. The first category we called efforts to circumvent. That is to say, efforts to bypass a locally elected prosecutor and have someone else make decisions about when to prosecute. So basically taking the discretion from one person and transferring it to another. So we saw, in Tennessee with a bill that I believe was passed that allows for the appointment of a special prosecutor. We saw bills in Missouri and South Carolina to allow police to bypass the local prosecutor and to bring cases directly to the state attorney general. Now, I should note, most of these bills were about targeting prosecutors who were bringing fewer cases, right? But that wasn't the only type of legislation we saw. We saw, for example, in South Carolina, a bill that was targeting prosecutors who were bringing cases against police for violent conduct, and took those cases away from police and said that they should go just to the state attorney general. Something similar in Texas, taking habeas death penalty cases away from local prosecutors and giving them to the state attorney general. So part of this circumvention was about trying to get prosecutors who were going to bring more cases, or decision makers who were going to bring more cases, but at least sometimes it was just to get the outcome that was desired politically, even if that meant fewer cases. So that's the circumvention category. We also saw bills or efforts that we characterized as sanctions. Removal, definitely a sanction, right? So Georgia, which I'm sure we'll be talking about quite a lot today. But in addition to that, a bill in Iowa to strip funding from prosecutors who seem to have even informal policies of not pursuing particular cases. An Illinois bill designed to create a private right of action for people if a prosecutor didn't bring a case. So really about punishing prosecutors who weren't bringing cases that other people might want to have brought. And then finally, and maybe most distressingly or shockingly, we saw takeovers. That is, efforts to stop communities from having their locally elected prosecutor of choice. One of the candidates who ran for governor in Pennsylvania ran on a platform about taking away Pennsylvania's right to elect its own prosecutor, which at the time seemed really sort of like a kooky thing for him to have suggested. But then we saw the state of Mississippi do it. Take part of Jackson, Mississippi, and appoint not just the prosecutor in that part of the city, but also the judges. So basically remove the possibility of folks living in part of that city to locally elect their criminal justice officials. A similar bill was proposed in Missouri, really just specifically targeting St. Louis prosecutor Kim Byrne. She ended up resigning in part to keep that bill from passing. So we have these three really sort of major categories. That's not to say that there was never legislation in the past that would have allowed this. Rachel, as you mentioned before, Florida already had a law on the books that allowed the governor to remove certain cases from state's attorneys there. The removal efforts that State's Attorney Worrell discussed were also under pre-existing legislation. There's a really good new paper. It's forthcoming in the North Carolina Law Review by someone named Megan Parsh that tracks all of those efforts and talks about how even these removal efforts in some ways are really about replacing the discretion of locally elected prosecutors who aren't following the desires maybe of certain state officials with others who might. So these are all efforts that we've seen to restrict the discretion of locally elected prosecutors. But something that I find very interesting is they're not about eliminating discretion, right? It's about replacing the discretionary decisions from these people with discretionary decisions that come from someone else.
Have we seen efforts like this before historically in this country? Are these unprecedented?
We have seen efforts. It's a little hard to track these things because at least the way law professors work, we usually spend far too much time looking at what happens in the federal system. But when my co-author and I were doing work on this, we found, for example, in the first half of the 20th century, efforts undertaken by states where you saw a disconnect between the urban areas that were largely populated by immigrants and by Catholics, and the fight that they had with state level officials that tended to be, native-born Protestants, fights over alcohol, fights over gambling. So in Wisconsin, for example, the state legislature passed a law in the 1940s requiring local prosecutors to pursue gambling violations that they found in their cities. So there have certainly been efforts in the past to curtail the discretion of prosecutors. I think what we're seeing now, though, is both that it's happening in many, many places at once, and that that people are paying attention. I mean, I'm sure the other panelists here could agree. People are paying attention to this, maybe in a way that they hadn't for several decades before.
Well, on that note, I want to turn to DA Boston to talk about what's been going on in Georgia, specifically with SB 92, which, as I mentioned earlier, established a commission with the authority to remove locally elected prosecutors. And there has been recent news that late before Thanksgiving, that the bill is essentially being stopped from being effectuated. And DA Boston, I want you to kind of explain what the bill did, the history of it, and then sort of what the status is right now, especially in light of this new ruling from the Georgia Supreme Court. And what does this update mean for the future of SB 92 and prosecutorial discretion in Georgia?
So just to give our folks attending a little bit of history, this past legislative session, which was January to March of 2023, the legislature that is Republican controlled passed SB 92, which created what's called the Prosecuting Attorneys Qualifications Commission. And that commission would have the power and the ability to investigate and discipline and remove elected prosecutors from office. And if removed, those people would be deemed unable to seek re-election in those offices for 10 years. It was a bill that had very little Democrat support and a large amount of Republican support, and support by both our governor and our attorney general. And so our governor signed the bill on May 5th, and on July 1st, the bill took effect. But in that bill, there were several things that had to happen in order for the commission to be able to do its work. First, the members of the commission had to first be appointed. All of those appointments were given to Republicans, and they made those appointments over the summer. There were 8 appointments. All 8 were given to men. 7 of those men were white males, and they were all Republicans. And so on August the 2nd, myself, along with 3 other Georgia district attorneys, with the help of the Public Rights Project, as well as some local counsel, filed lawsuits against the state of Georgia to challenge the constitutionality of the commission, as well as seeking an injunction to prevent the commission from moving forward while we were making our challenges. And so over the course of this year, we have been in court. We have been pushing our lawsuit through and making arguments. However, during that time, the commission, which had already been appointed, had submitted their rules to the Supreme Court in hopes of adopting them. Let me just back up and say that we also saw on October 1st, which was the date set in the bill as the first official date that any complaint could be filed, was on October the 1st. And we saw our first complaint come on October 1st. And that was against my sister friend DA, just on the other line of me, Fani Willis, for her decision to indict the former president and 18 other or 17 other co-defendants in an election fraud case. And so what we saw, as my dear sister, State's Attorney Worrell said, was we saw Republicans now trying to usurp independence of a duly elected prosecutor from choosing to prosecute a crime that happened in her jurisdiction. And so they filed their very first complaint against her, alleging that she was violating her oath of office by prosecuting these or indicting these defendants. And dare I say, this was after a special purpose grand jury made the recommendation, and then another criminal grand jury actually presented or true billed that indictment. That's what we saw. And so, and ultimately the funny part, or not so funny if you think about it, is the notion is that DA Willis shouldn't be using these resources to go after a former president when she should be using her resources to deal with the violent crime in her community. Sound familiar? It should, because when we talk about the issues of prosecutor discretion, we're also really talking about prosecutor independence. And that's what we argued in our lawsuit. Prosecutors have to have 2 things: the discretion to make decisions on how to best utilize their resources to make their community safe, but the independence to make decisions on what prosecutions are deemed to be the most important and are the best uses of not only their resources, but so impactful and so important to the community. And so what we're seeing is exactly what State's Attorney Worrell just said, which is it's not about prosecutor discretion and it's not about prosecutor independence. It's about certain legislators wanting to dictate exactly what elected prosecutors are doing with their offices, and more importantly, whom they are choosing to use those resources on. And so that's what our lawsuit was all about, that we have to have both our independence and our discretion to make these very important decisions. Here in Georgia, it is still a crime. As Carissa pointed out, there is still a crime to fornicate, to commit adultery. Those crimes have never been removed from the books here in the state of Georgia. But I don't know any of my colleagues, elected prosecutors across the state of Georgia. I have not seen anyone that is prosecuting a crime of fornication or adultery in the state of Georgia. And that's because we are not using we as prosecutors are using our system to make sure that we are keeping our communities safe and not engaged in that kind of political theater. And my co-plaintiff, DA Jonathan Adams, who lives in a rural jurisdiction where, by the way, judges will sign warrants for adultery, he had to have a blanket policy that he put before the court to say, I'm here to let you know that if you sign a warrant and have someone arrested for adultery, that is within your judicial ability to do. But I'm here to tell you that we will unilaterally dismiss those cases because we do not believe that we should legally be prosecuting people for adultery in our jurisdiction. And so I'm glad to have he as our sole Republican in our class of plaintiffs challenging this law. But luckily, just this past week, we got a victory in the sense that the Supreme Court declined to adopt the rules that the Prosecutor Commission put forth. And in their declination, they said, we don't believe that we have the constitutional authority to act in the way that the legislature has written for us to do. So as it stands, the PAQC cannot operate without rules, and the Supreme Court has said we will not adopt rules. So where does this all leave us in Georgia? Well, our case or the rules will go back. And I imagine that when the legislative session starts in January, you're going to see a number of Republicans that are trying to strike out the Supreme Court out of the law so that they can find a way to move forward or adopt rules to allow the PAQC to start its work. Our lawsuit is still pending, but we are really grateful that the Supreme Court in its 6-page order has pointed to what we think are some of the very concerns that we have laid out in our lawsuit about the constitutionality of the process and about the constitutionality of the commission and the concerns about how you regulate elected district attorneys for conduct that is not already or outside the regulated duties of the Georgia Rules of Professional Conduct, which are regulated by the State Bar of Georgia, or obviously the criminal code for any DA or any elected official that chose to violate a criminal statute for which they would be prosecutable by the Attorney General's office. So we are very excited that we are being heard, that we are fighting on the ground for our independence and our discretion, because it is the backbone of who we are, and our communities and the voters deserve the right to choose their elected officials and hold them to task if they are not, in fact, upholding the values for which they were elected to do.
Thank you so much, DA. And we'll be following the developments closely. And I should mention that the IIP did file an amicus brief in support of the litigation you were just talking about by you and other prosecutors in Georgia. State Attorney Worrell, I want to bring you in here. I saw you nodding a little bit when DA Boston was talking about the community aspect, right? Of how these decisions about independence, as DA Boston put it, are really about what communities have decided to support by way of their elected prosecutors. So can you talk about that angle in terms of how this kind of attack is really undermining communities? And what would you say to states that are considering legislation like this in terms of the impact on communities specifically?
Sure. So I was elected with nearly 67% of the vote. 397,000 people cast their vote for me in the November election of 2020. The reason that's important is because I ran on full transparency about what I stood for, the things that I would do, and how I would utilize the resources of the Ninth Judicial Circuit for public safety in a way that incapacitated individuals who were in fact a danger to our community, but also engaged in programming and providing resources into communities that were struggling, and research-based things that help communities grow and help individuals become productive members of our community that go above and beyond any benefit that incarceration could ever provide. The people voted for that. The people voted to have law enforcement be held accountable for misconduct and for violence on the community. The people voted for children to be treated like children. The people voted for drug addicts to be given rehabilitation instead of prison, and for drug traffickers to be treated like the criminals that they are and incarcerated as such. When the governor removed me from office, he said, I don't care what the people asked for. He said, I am nullifying the votes of the 397,000 people who voted for this platform. And instead, I am replacing it with my will, as though Florida is some sort of kingdom over which Ron DeSantis is the king. So the appointed state attorney has currently implemented a policy that essentially charges drugs upon referral from law enforcement. How this differs from what I used to do is that we understand that field presumptive testing of narcotics is sometimes wrong. In fact, here in Central Florida, there are two recent cases where law enforcement pulled someone over. They saw a substance that they believed to be an illegal substance. They did a field presumptive test for the alleged illegal substance. The field presumptive test was positive. And in one case, after laboratory testing, it came back that the substance was glaze off of a donut. And in another case that came back that it was drywall. In both of those cases, those individuals were arrested, but not yet prosecuted. What the current appointed state attorney is doing is he's going forward with prosecution. He's taking those cases and basically ramming them through the system, and people are pleading out to cases before the proper analysis comes back from the laboratory to confirm that the drugs are actually the drugs. The people didn't vote for that. That's not what they voted for. They voted for someone who understood that field presumptive tests are 20% inaccurate, and that we need to ensure that when we bring charges against someone, that we can sign our names and say that we believe that this person is guilty beyond a reasonable doubt. But beyond a reasonable doubt is just kind of a throw aside for the appointed state attorney's office. They go forth with cases based on reasonable suspicion or probable cause. They have taken grand jury for law enforcement involved incidents. So if there's a police shooting, my office would conduct an investigation independent of law enforcement's investigation. And we would make a determination to bring charges or not to bring charges based on the use of our discretion in our office. The appointed state attorney has now taken all of these cases and said the grand jury is going to make a decision. But the people didn't vote for that, because the grand jury proceeding is a private proceeding, and the people don't have transparency in what's happening in that grand jury proceeding. The state has an enormous influence over what information the grand jury is provided with, and therefore what decision the grand jury ultimately makes. So what has happened in Central Florida, and I believe the same is happening in Hillsborough County with the appointed state attorney there, is that the people have justice being administered in ways that they did not vote for, not only in ways that they didn't vote for, but in ways that they explicitly voted against. Because there were candidates in my election who proposed the type of justice that the appointed state attorney is currently carrying out. And the people voted against that. One particular individual who now currently is working in the office as the chief assistant ran against me and received 6,000 votes. So the people explicitly said they did not want his style of justice. But now, because of the governor, they are forced to accept his style of justice. And this is wrong. And what I would say to any other state who's considering this, we have a democracy in this country. And until the time comes that we change that and decide that instead we want a dictatorship, then elections have to stand for something. This is just as bad as the insurrection. It is election denying. And in the same way that Trump refused to accept the election of Joe Biden as president, the governor of Florida is currently refusing to accept the election results of other elected officials who happen to be Democrats in the state of Florida. So what is happening is we are eroding the very tenets of democracy in this country. And we should really pay attention. I was on the phone today with one of my constituents, and she said, we're old now, so we don't have to really bear the brunt of what's happening in this country. But the younger people, they're the ones who are going to suffer as our democracy slips away from us.
That's powerful and ominous words. And I think, I often think about these attacks as different tools, all of the same toolkit that are being used in different states, depending on what avenues are available. And with that in mind, I wanted to turn back to you, Carissa, to talk about what are other strategies that we're seeing as part of this toolkit to undermine democracy, as State Attorney Worrell just talked about. What are some of the other examples of ways and strategies that other states have used to either remove prosecutors or to undermine the will of voters in electing them?
Yeah, I think probably the most visible is impeachment, and in particular the impeachment of Larry Krasner in Pennsylvania. And I'll just say, slightly off topic, but following up on State Attorney Worrell's comments, I think one of the reasons that this is so difficult is it's a question not just of democracy or not democracy, but democracy at what level? Because we can certainly say that if you have a locally democratic, a locally elected official, that we had a particular community make decisions about how that community was going to govern itself. When we start talking about the state level, we also have a claim to democratic legitimacy. It's just at a different level. And then again, at the federal level. And sometimes our thoughts about how democracy should play out in those situations might depend upon the particular issue. So in New York, for example, several years ago now, like within the past decade, but not very, very recently, the state legislature, after years and years and years of lobbying, finally enacted legislation to create a disciplinary review board for prosecutors, because there had been so many claims of abuse in terms of violation of discovery rules, inappropriate arguments during opening and closing statements. Now, there was really sort of, I think, there wasn't a very good argument that these things weren't happening, right? There were lots of appellate decisions from the courts in New York talking about, sort of rampant misconduct, in particular at a few offices. And yet the voters were continuing to elect those prosecutors year after year after year. Now, if you are really concerned about what's happening in those individual cases, you might be happy for the state of New York to step in and say, we're going to do something here. But if you instead are talking about our community doesn't want to be throwing people in jail for possessing marijuana, then the state stepping in to say you have to do that looks like overreach, and it looks like a real problem. So I don't want to suggest that democracy isn't an important value here. It's an incredibly important value. But there's also this question about what role we should have different layers of government playing in all of this. And that's really the fight in Pennsylvania right now. There's no doubt that the people of Philadelphia overwhelmingly support the path that Larry Krasner is taking to address crime in his community. But in the state more broadly, he's quite unpopular. He was impeached by the House of Representatives. There's ongoing litigation. The Supreme Court of Pennsylvania just heard arguments, I believe it was earlier this week, about litigation going on there. A flip in the state house may sort of undermine the proceedings regardless of what happens in court. But it's not just a question of bills that are being passed. It's also a question of other removal efforts and sort of toolkits that state officials already have that they can use in these fights with local communities. And I say, by the way, fights with local communities as someone living in the state of North Carolina, where our state legislature is constantly fighting with our local communities about what bills we can have, about transgender people in back rooms or Confederate monuments and those sorts of things. The relationship between state and local governments is incredibly fraught. And I think it's important to keep in mind that our views about who's in the right in those fights is probably really going to depend on the quality of the decisions that they're making as well.
Thank you. And you just mentioned litigation, and we've been talking about, of course, the litigation in Georgia, but I wanted to ask you, State Attorney Worrell, about your litigation right now, challenging your suspension at the Florida Supreme Court. I believe you have arguments scheduled next week. Can you walk us through the approach that you're taking in terms of challenging the suspension and what you hope to accomplish?
Yeah, so my case will be heard before the Florida Supreme Court on Wednesday, December the 6th. There have been several concerns raised that the Florida Supreme Court was more than a majority appointed by the governor. But it is really important that we continue to rely on the courts to make decisions that limit the governor's power, because that is justice. And we are in a place right now where people can feel that their votes don't matter. There is already a feeling about a mistrust within the criminal legal system. That's one of the things that I've worked really hard during my tenure to try to resolve, is rebuilding community trust in the courts. And I say that to say now more than ever, people need to be able to trust in the courts. So I know that there is a bus that is leaving from Central Florida to go up to Tallahassee to participate and watch the proceedings on Wednesday. And this is, a really historic occasion because it's never happened before. There is really no precedent for this sort of thing to be done. So my argument hinges on the fact that the governor's executive order of suspension, while it named neglect of duty and dereliction of duty as the reasons for my suspension, it did not identify any actual acts that were neglectful or could be classified as dereliction of duty. He broadly discussed policies without identifying any actual policies. He broadly discussed prison incarceration rates in comparison to the incarceration rates of other offices in the state. But let's be very clear, and one of the things that DA Boston hit on earlier was a prosecutor and an attorney's ethical responsibilities. If we look at the ABA model rules with regards to the responsibilities of a prosecutor and any other ethical responsibilities of a prosecutor, there is no duty to maximize incarceration. So while the governor disfavors the fact that incarceration rates are lower under my administration, there's no ethical duty for me to maximize incarceration rates. So that can't possibly be a legal reason for my removal because there is no duty to do that. Additionally, when it comes to violent crime, murder, rape, things of that nature, sexual assault, there are circuits that fall behind my circuit in incarceration rates. Because what I told the people of Central Florida that I would do was utilize incarceration to incapacitate those individuals who are an actual danger to our community, not for those individuals who need to be rehabilitated in some way, shape, or form. So when it comes to those violent crimes, you will see that there are other circuits in Florida whose incarceration rates actually fall behind the Ninth Judicial Circuit, but yet those prosecutors weren't removed from office. So the argument is based on the fact that this is solely a political suspension, and that political expediency is not defined as a proper basis for removal by the Florida Constitution, and that it is incumbent upon the Florida Supreme Court to draw a line, because this governor is out of control. As I mentioned earlier, he has suspended more elected officials than any prior governor. And the bulk of those elected officials have been suspended for being Democrats. And it is really important that the governor, that the Supreme Court not allow the governor to suspend them from doing their job and separating powers and ensuring that the governor is required to provide a legal basis for suspension of an elected official, and not just grasp of straws and provide a very vague basis for suspension, for a few reasons. Not just because that's justice for me, but essentially what you will find is that no one will know what they can do to be suspended anymore. What we will see is individuals who are ramping up their incarceration rates out of fear of being removed. What you see is happening with the appointed state attorney in my circuit is that they're ramping up conviction rates for drugs without regard for whether or not the individuals are actually guilty of the crimes that they're being convicted for. This is a very dangerous situation in the criminal legal system, because there is no longer regard for wrongful conviction. There's no longer regard for officer credibility. And there's no longer regard for the things that have been proven by data and research to enhance and increase public safety in communities. It is now just about making sure that people incarcerate enough people so that the governor will be pleased. And that is a very dangerous place for us to be.
So I want to ask you sort of the flip of that question, State Attorney Worrell, because as you've talked about, there seems to be this effort to ensure that there's enough incarceration, more incarceration, and some would say that limiting prosecutorial discretion can actually be a good thing in the other direction, because for so long prosecutors have gone unchecked when they've created great harms in the legal system, many of which you campaigned and won on trying to address. So how do you respond to the argument that limiting prosecutorial discretion can actually address some of the harms in the legal system, or that it may be a good thing?
So I don't think it can be a good thing. I think it's the same problem that we saw when we put, and I don't know if this is the case in other states, but here in the state of Florida, we have minimum mandatory sentences. So that takes away the discretion from the judge. And part of the reason that we did that is because judges were being too harsh in their sentencing. So we were making sure that there were guidelines and saying that you can't sentence this person to, 36 months in prison and then give this person probation, right? Because the disproportionate minority representation in the criminal legal system, specifically in those people that we put in custody, was seen through those approaches. So we put it across the board and said, you no longer have discretion. If a person scores this amount, then they have to serve this amount in prison. Well, what we've seen is great injustices come from taking away judicial discretion, because while the former was true, that we did see the potential for abuse of discretion that was racially based, what we've seen now is that you have situations where you have a first-time offender who's never been in trouble ever, who was in the wrong place at the wrong time, who's charged with a trafficking offense and ending up in prison for 30 years. And the judge has no discretion to do anything about that. So in the same way, if we limit discretion of prosecutors in the way to say that you can't charge this offense and you have to bring, well, who then is going to have the discretion? Because someone has to have it. So are we then going to pass that discretion on to law enforcement? Because that's what's been done in my jurisdiction. One of the things that the governor used as a basis for my suspension was the law enforcement referred so many offenses and I didn't prosecute all of those offenses or a number of those offenses. And because I didn't comply with the will of law enforcement, that was used as a basis to show my neglect. So I guess what I'm saying is someone has to have the discretion. And if it's not going to be the judges, and if it's not going to be the prosecutors, then who are we going to entrust with the discretion to decide who spends decades to life in prison or not?
So I'd like to jump in on this and follow up on State's Attorney Worrell's point by pointing to the exact scenario of where communities are upset that a prosecutor does nothing. The first iteration of SB 92 came from the case of Ahmaud Arbery. In 2020, we had Ahmaud Arbery that was murdered in the streets of South Georgia. And we had a DA at the time who, for a number of reasons, made a decision that no crime had occurred and that she was pushing this, not seeking to do her job in that case, right? And when we all saw that video, we were outraged of why a murder of a Black man by 3 white men would not be prosecuted. And so obviously, once the video came to fruition, we had an attorney general and a governor and many others that were questioning the decision of the prosecutors, let me say, because there were 2 elected district attorneys that were involved in that decision. That was when the first iteration by Democrats came of, we need to make sure we're holding prosecutors accountable. And at that time, I reached out to the Democratic leadership and said, let me talk to you about why a commission is not the right way to address an issue of prosecutor decision-making. And I don't agree with the decisions made by this prosecutor. And ultimately, this prosecutor did a number of things wrong that eventually led to her being charged criminally, which she is standing charges now for by the Attorney General. Ethically, which led to the State Bar of Georgia dealing with those issues. But perhaps the most important thing was the voters. On that next election, she had a challenger. And the voters said, after seeing what happened to Ahmaud Arbery and how our prosecutor handled this case or chose not to handle it, we want her out. And they voted her out. And they voted her out before she was charged. They voted her out before the state bar had an opportunity to go through that process, right? The voters said, you are not operating that office in a way that we think meets the values of this community, and you are gone. And so I say that to say is that despite what she did, I did not, and I told Democratic legislators, I don't support a commission being in charge of making this decision, because there are a number of things that went wrong that we have in place for. But most importantly, the voters have the right to decide who should be making decisions. And by the way, this particular DA had made other decisions in other cases that had already gotten media attention, right? And so I think it's important to note that while those Democrats were well-meaning, but importantly, once they heard what I said, they said, you know what, you're absolutely right. And they decided that they would no longer support or sponsor this type of legislation as a delegation. And I warned them at that time in 2020, because I saw the writing on the wall. I saw what was happening across the country. I saw the backlash, and I said, while you are well-meaning in your efforts to make sure that prosecutors are holding the right people accountable, there will be a large group of people that will use this opportunity to turn the tables and go after prosecutors that have decided to stand in the gap and protect their communities and make sure that prosecutors are doing the right thing. And that's exactly what we see happen here in Georgia. It was no longer a conversation about DA Jackie Johnson and what she didn't do to make sure there was justice in the murder of Ahmaud Arbery. It became about DAs that look like me and DAs that are Democratic doing things that served our community and prosecuting people that they didn't want us to prosecute.
There's a lot to unpack there. And I see we have some questions in the chat, so I'm gonna try to move through some of the other questions I had. So I wanted to talk a little bit about some of the practical effect of these attacks on the ground for line prosecutors, many of whom are with us today watching, and will be watching the recording as well, and how, I guess, DA Boston, I'll stick with you. How did these kinds of attacks and the looming SB 92, how does that affect line prosecutors? And how does it affect you as an elected prosecutor in terms of your communication with your community?
Well, I mean, it's been a difficult road to navigate because SB 92 was not exactly clear on what we could or could not do. So not only did they create a commission, they made it very murky and blurry as to communications, because it says policy written, spoken, or otherwise, right? And as district attorney, one of the things that we are forced to do is we are elected officials. So it means we are on campaigns, we are at forums, we are at debates, we are asked questions in town halls by our community members and our constituents. And as someone that ran on accountability and transparency and honesty, and things that we've been, doing for years, people have been asking questions of what is your approach on this kind of case? It has hindered our ability because I don't know if what I'm saying in this forum right now could trigger someone to file a complaint against me, right? And so my line attorney's experience is, they have concerns about what if what I'm doing is putting my elected prosecutor at risk, because it's also very clear that while this commission can't remove them, but the actions of a line and prosecutor can be impugned to the elected DA. So I know that many of my prosecutors are like, are things that we say and we do and how we approach our cases. Do we have to indict everything, right? The current SB 92 law says that you're supposed to examine every single case for which probable cause exists, right? That's in SB 92. But here in the Dekalb District Attorney's Office, we have a bill of values that we adopted. And one of our bill of values says that in this office, you should not indict a case for which you do not believe that you can prove beyond a reasonable doubt. So SB 92 collides with the very value set that I have asked each and every member of my team to ascribe to. So they're saying to themselves, do I follow this high burden that my DA has asked me to do, which, by the way, is the same burden that I'm going to be required to prove when I go to court, right? Or do I look at things from this lower threshold, which is not the burden that I have in court, because some commission says that I have to prosecute every case for which there is probable cause for. So these things are not the same, and they have created a lot of concern and confusion and uncertainty amongst not just electeds, but line prosecutors that just want to do the right thing. And by the way, aren't elected and don't want to be in the political part of it. They just want to serve their community, and without all of the extra fanfare.
Sure.
Yeah, and Rachel, I know you want to get to some other questions, but if I could just emphasize what DA Boston just said, the consequences of what's happening here are really troubling, right? So State Attorney Worrell was talking earlier about, and I think she's correct, there's no way to read the order from Ron DeSantis other than he wants her to make different decisions. He hasn't reviewed these individual cases, so it's not as though he's made the decision. He just wants different decisions to be made. I think that's troubling. I think it's perhaps even more troubling to adopt policies that say elected district attorneys cannot set policy for their unelected employees. I just find it incredibly difficult to justify a rule or an institution that would say the person who's been elected to do this job can't tell the person in her office what to do. And to compound matters even more, we're going to create a commission that is staffed by people who were not elected by the rest of the state. This is an impeachment. These are commissioners who were elected by different local communities who will then use their discretion to assess the discretionary decisions that are made by DA Boston and others. So to the extent we want to talk about democracy, the idea that these moves are about having unelected people or people literally elected in different communities and not your own in charge of these decisions, really difficult to justify those sorts of policies. Sorry, I know I spoke out of turn.
No, I'm so glad you did. State Attorney Worrell, I wanted to ask you also on the practical side, how has your suspension impacted your office and your community? And how do these kinds of attacks affect office dynamics and retention and all those kinds of things?
So when it became clear that every single decision was subject to media, was subject to law enforcement's review, and by that, I mean, very early on, there was a decision that a prosecutor had made to not give a 3-year minimum mandatory to an individual who was a convicted felon in possession of a firearm. And the reason he did that is because the law says that if they were in possession of the firearm and it wasn't being used to commit another crime, then the state attorney has discretion to not charge that person with the minimum mandatory. So he used his discretion and didn't charge the person with the minimum mandatory. Well, as fate would have it, this individual then went out and ended up being accused of a homicide. And the media story was, look at what she's doing. I had no idea because I did not have the file and I did not weigh in on the decision at all. But as DA Boston said earlier, the decisions of the assistants are attributed to the elected. But it was well written in the notes. It was well documented and justified that the law allowed for the decision that he made. And one thing that I said throughout my entire tenure was that prosecutors do not have a crystal ball. We can only make a decision based on what is before us today. There was no way for him to know that this individual would go out and then end up being accused of a homicide. But it was all over the news and it was a huge scandal. And the assistant state attorney had an extreme amount of pressure on him. And from that point on, and as the discussions of my removal started being kicked up by the governor and by law enforcement, people were in fear, constant fear, that the decision that they made could lead to my removal. People were leaving the office because, as DA Boston said, they did not sign up for a political work. These are people who just wanted to serve their communities. And the pressure of consistently having every decision being a news story was too much pressure for many of them to take. And for those who didn't leave and stayed, they often came to me and discussed how the pressure affected them. And then after my removal, most recently, a week ago, someone was fired. And they were fired, and the reason that they were given was because they did not impose a minimum mandatory sentence. And they looked back to 2 years prior and said, and you did that before too. So because on these 2 occasions, you didn't impose a minimum mandatory sentence, we're firing you. So what does that do for morale? Who wants to come work in an office like this? Only the people who were of the old guard and want to maximize incarceration. No one else wants to do that. No one else wants to work under that regime. But then you have people who will do whatever the top says, and they don't feel the stress either way. Whoever is sitting in the elected seat, in this case, the appointed seat, they'll do whatever has been handed down to them, but they still aren't there for the political drama of having every single decision that they make being second guessed. And that's what this does. That is the fallout. The additional fallout is that you have children who are now being prosecuted because the appointed state attorney needs to impress upon the governor that he's doing it the way he wants it done. Children that never would have been prosecuted under my administration because I made a commitment to the community that but for a homicide, we will, or a very dangerous situation, we will keep children in juvenile court. Well, the appointed state attorney has gone on the news several times, which, because surprise, surprise, crime hasn't stopped with my suspension, to talk about how he's going to charge 14-year-olds to the fullest extent of the law. The people didn't vote for that. So the community is impacted because they are having their community prosecuted in accordance with the governor's wishes instead of with theirs.
Thank you. I want to get to some questions, but I want to give each of you an opportunity to kind of say a last word first. And my grounding question for my lightning round, so short answers, please, so we can get to some questions. And I'm sorry I know there's a lot more we could all discuss, but I wanted to ask, what steps can prosecutors and community members and advocates take to assist prosecutors who are under attack, and criminal justice reform that's under attack? And also with a specific focus for you, Carissa, maybe you can start with how can we combat some of the false narratives around these attacks on discretion and prosecutorial reform?
Yeah, I think the most important thing when it comes to prosecutorial discretion is to make the American public understand that it is unavoidable. Someone has to make discretionary decisions. And once they realize that that's going to happen, I think that there will be more support for the idea that those decisions should be made by locally elected officials and that they should be made in a relatively transparent manner so that you can have local voters weighing in. Because unfortunately, that's just not what people think now. They think there are prosecutors who enforce all of the laws, and then there are these new progressive prosecutors who just let crime run rampant. Both of those categories are false categories, and it's certainly a false dichotomy.
DA Boston.
I think we need to make our voices be heard. I mean, I said it before when this bill was signed by the governor. SB 92 is an assault on democracy. We are watching our country in many areas assault our very democratic process and continue to want to disenfranchise voters from making the decisions for their own communities to be superseded by others for whom are not accountable to them. So it's important for everyone in their community to understand that they have a voice and they have a vote, and they need to fight to make sure that that voice and that vote are neither diluted or taken away.
State Attorney Worrell.
I concur with everything that has been said by my co-panelists, and I would just end with this. Criminal justice reform is not what it's being painted to be. Criminal justice reform is not making our communities less safe. Criminal justice reform is not failing to hold people accountable when they commit crime, and it's not opening the prison doors and letting everyone out. Criminal justice reform is simply realizing the mistakes that we've made in the future, learning from them based on data and research, and making better decisions to make our communities stronger and safer.
Absolutely. We have 3 questions we're going to try to get through in the next 9 minutes, and maybe I'll direct one of them to each of you. Let me ask you this, DA Boston, can these removals be seen along with voter ID acts and gerrymandering as part of a wider effort to disenfranchise communities of color from their voting power?
Absolutely. I mean, that's exactly what we said, is that, prosecutors have been utilizing discretion and independence since the beginning of time. And so what you have seen is prosecutors that are committed to doing things differently being elected wholesale and representing more people in the largest areas across the country. And when, despite attacking those prosecutors, when they are reelected, duly reelected by the community, they're just like, well, if we can't get communities to vote them out, then we need to find another way to remove them. And so it is disenfranchisement. It is removing local control. It is akin to gerrymandering and making it difficult to vote.
Next question I'll ask you, Professor Hessick, is there a specific statutory or case authority that empowers elected prosecutors to unilaterally not prosecute entire classes of crime based solely on the DA's personal or political views, or is the argument that such prosecutorial discretion is purely inherent in being elected?
Yeah, no, that's a great question. And unfortunately, I can't give a single answer because there are 50 states with lots and lots of different sort of case law and constitutional choices that have been made. I will say that the cases that are probably the most well-known here are the federal cases, where we aren't even talking about elected prosecutors. We're talking about, in some of the cases, sometimes we're talking about appointed prosecutors, sometimes we're talking about state prosecutors. And the US Supreme Court has taken a very hard line on prosecutorial independence from the oversight of the courts. So there is this sort of Article 2 take care clause type argument out there about prosecutors having this as part of their enforcement power, also having discretion that isn't reviewable.
Thank you. And our last audience question for State Attorney Worrell: how are constituents pushing back on these authoritarian levels of abuse of the judicial system in Florida? If their votes are disregarded, how do they address those issues? And the person says, I live in a Dem state and in LA, but even here there's a push to impeach DA Gascon.
So voters here have been very vocal. They showed up for a rally the day after my suspension. As I mentioned earlier, there's a bus trip going up to Tallahassee for my Florida Supreme Court hearing to show their, support. But what can people do? You have to be vigilant. You have to continue to raise your voice. You have to continue to protest these decisions. You have to continue to be civically engaged and elect individuals who will carry out the will of the people and not support things that allow disenfranchisement. Here in the state of Florida, the 2 areas where prosecutors were suspended from served the majority of Black and brown people in the state. So yes, this is gerrymandering. Yes, it is voter disenfranchisement, and we cannot stand for it. There are people who came before us who fought, some of them died, for our rights to have a say in our electoral process, and we have to do everything that we can to preserve it.
Great words to end on. And I'm sorry, there's so much more we could discuss, including some of the details of other bills. And I know that the IIP is going to continue to focus a lot of our attention on this issue, which continues to be of the utmost importance as we've been talking about today. So I want to thank our guests. And again, I wish we had even more time to talk with you all, but thank you so much for sharing your insight and wisdom. And we will continue to, as I mentioned, prioritize this issue. And for more information on some of the work that we've been doing, some of our writing and other work on this topic, you can go to prosecution.org. We'll also be posting today's recording as soon as possible. And please make sure to sign up for our mailing list if you haven't already, so that you don't miss our future events. thank you so much again to our guests. We really appreciate your time, and we continue to offer you our support in everything that you do. So thank you so much, and we will see you next time.